Module 9, Residents' Rights. The purpose of this module is to teach trainees residents' rights and the importance of enforcing those rights. Objectives. Upon completion of this module, the trainee will be able to demonstrate knowledge of the Resident Bill of Rights, identify the ways for residents to file complaints, identify entities available for residents' advocacy, and ways to inform residents about them, demonstrate knowledge of the civil actions that may be taken to enforce rights, demonstrate knowledge of the statutes and rules regarding availability of third-party services. Demonstrate knowledge of the conditions allowing residents to work in the facility. Demonstrate knowledge of the mandatory abuse, neglect, and exploitation reporting requirements for all staff. Demonstrate knowledge of the standards applying to the use of physical restraints. Demonstrate knowledge and understanding of surrogate decision makers for residents, including guardianship, in order to protect the health, safety, and welfare, including financial resources of residents. Demonstrate knowledge and understanding of the facility policies and procedures regarding advance directives and do not resuscitate orders. Residents' rights and facility procedures. A copy of the Residents' Bill of Rights or a summary provided by the Long-Term Care Abundance Program must be posted in full view in a freely accessible resident area and included in the admission package provided. No resident of a facility shall be deprived of any civil or legal rights, benefits, or privileges guaranteed by law, the Constitution of the State of Florida, or the Constitution of the United States as a resident of a facility. Every resident of a facility shall have the right to live in a safe and decent living environment, free from abuse and neglect. Be treated with consideration and respect and with due recognition of personal dignity, individuality, and the need for privacy. Retain and use his or her own clothes and other personal property in his or her immediate living quarters, so as to maintain individuality and personal dignity, except when the facility can demonstrate that such would be unsafe, practical, or an infringement upon the rights of other residents. Unrestricted private communication, including receiving and sending unopened correspondence, access to a telephone, and visiting with any person of his or her choice at any time between the hours of 9 a.m. and 9 p.m. at a minimum. Upon request, the facility shall make provisions to extend visiting hours for caregivers and out-of-town guests, and in other similar situations. Freedom to participate and benefit from community services and activities, and to pursue the highest possible level of independence, autonomy, and interaction with the community. Manage his or her financial affairs unless the resident or if applicable, the resident's representative, designee, surrogate, guardian, or attorney-in-fact authorizes the administrator of the facility to provide safekeeping for funds. Share a room with his or her spouse if both are residents of the facility. Reasonable opportunity for regular exercise several times a week and to be outdoors at a regular and frequent intervals except when prevented by inclement weather. Exercise civil and religious liberties, including the right to independent personal decisions. No religious beliefs or practices, nor any attendance at religious services shall be imposed upon any resident. Assistance with obtaining access to adequate and appropriate health care. For purposes of this paragraph, the term adequate and appropriate health care means the management of medications, assistance in making appointments for healthcare services, the provision of or arrangement of transportation to healthcare appointments, and the performance of healthcare services which are consistent with established and recognized standards within the community. At least 45 days notice of relocation or termination of residency from the facility unless, for medical reasons, the resident is certified by a physician to require an emergency relocation to a facility providing a more skilled level of care, or the resident engages in a pattern of conduct that is harmful or offensive to other residents. In the case of a resident who has been adjudicated mentally incapacitated, the guardian shall be given at least 45 days notice of a non-emergency relocation or residency termination. Reasons for relocation must be set forth in writing and provided to the resident or the resident's legal representative. The notice must state that the resident may contact the state long-term care ombudsman program for assistance with relocation and must include the statewide toll-free telephone number of the program. In order for a facility to terminate the residency of an individual without notice as provided herein, the facility shall show good cause in a court of competent jurisdiction. Identify the ways for residents to file complaints. Identify entities available for residents, advocacies, and ways to inform residents about them. The telephone number for logging complaints against a facility or facility staff must be posted in full view in a common area accessible to all residents. The telephone numbers are the Long-Term Care Ombudsman Program, 1-888-831-0404. Disability Rights Florida, 1-800-342-0823. The Agency Consumer Hotline, 1-888-419-3456. The statewide toll-free telephone number of the Florida Abuse Hotline, 1-800-96-ABUSE or 1-800-962-2873. The telephone numbers must be posted in a close proximity to a telephone, accessible by residents, and the text must be a minimum of 14-point font. Present grievances and recommended changes in policies, procedures, and services to the staff of the facility, governing officials, or any other person without restraint, interference, coercion, discrimination, or reprisal. Each facility shall establish a grievance procedure to facilitate the residents' exercise of this right. This right includes access to ombudsman's volunteers and advocates, and the right to be a member of, to be active in, and to associate with advocacy or special interest groups. The administrator of a facility shall ensure that a written notice of the rights, obligations, and prohibitions set forth in this part is posted in a prominent place in each facility and read or explained to residents who cannot read. The notice must include the statewide toll-free telephone number and email address of the State Long-Term Care Ombudsman's Program and the telephone number of the local Ombudsman's Council, the Elder Abuse Hotline operated by the Department of Children and Families, and if applicable, Disability Rights Florida, where complaints may be lodged. The notice must state that a complaint made to the Office of State Long-Term Care Ombudsman or a local Long-Term Care Ombudsman's Council, the names and identities of the residents involved in the complaint, and the identity of complaints are kept confidential, and that the retaliatory action cannot be taken against a resident for presenting grievances or for exercising any other resident's right. The facility must ensure residents access to a telephone to call the State Long-Term Care Ombudsman's Program or local Ombudsman's Council, the Elder Abuse Hotline operated by the Department of Children and Families, and Disability Rights Florida.
Demonstrate knowledge of the civil actions that may be taken to enforce rights. Any person or resident whose rights are violated shall have a cause of action. The action may be brought by the resident or his or her guardian, or by a person or organization acting on behalf of a resident with the consent of the resident or his or her guardian, or by the personal representative of the estate of a deceased resident, regardless of the cause of death. If the action alleges a claim for the resident's rights or for negligence that caused the death of the resident, the claimant shall be required to elect either survival damages or wrongful death damages. If the action alleges a claim for the resident's rights or for negligence that did not cause the death of the resident, the personal representative of the estate may recover damages for the negligence that caused injury to the resident. The action may be brought in any court of competent jurisdiction to enforce such rights and to recover actual damages and punitive damages for violation of the rights of a resident or negligence. Any resident who prevails in seeking injunction relief or a claim for an administrative remedy is entitled to recover the cost of the action and a reasonable attorney's fees assessed against the defendant not to exceed $25,000. Third-party services. Nothing in this rule chapter is intended to prohibit a resident or the resident's representative from independently arranging, contracting, and paying for services provided by a third party of the resident's choice, including a licensed home health agency or a private nurse, or receiving services through an outpatient clinic, provided the resident meets the criteria for admission and continued residency, and the resident complies with the facility's policy relating to the delivery of services in the facility by third parties. The facility's policies must require the third party to coordinate with the facility regarding the resident's condition and the services being provided. When residents require or arrange for services from a third-party provider, the facility administrator or designee must allow for the receipt of those services, provided that the resident meets the criteria for admission and continued residency. The facility, when requested by residents or representatives, must coordinate with the provider to facilitate the receipt of care and services provided to meet the particular resident's needs. The administrator or designee must ensure that care coordination includes documented communications about the resident's conditions and response to treatment or services ordered by the physician, which may impact the resident's appropriateness for continued residency in the facility. Communications occur at least every 30 days and whenever there is a significant change in the resident's condition. And if physician-ordered treatments or services occur less often than once a month, communications must be conducted according to the ordered treatment or service schedule and whenever there is a significant change in the resident's condition. When communication with the third-party provider is unsuccessful, at least 2 attempts at communication on 2 separate days must be documented. Documentation must include the name of the person from the third-party provider with whom contact was attempted, the method of communication, and the date and time of the attempts. This documentation must be included in the resident's record in accordance with the timeframes. If residents accept assistance from the facility in arranging and coordinating third-party services, the facility's assistance does not represent a guarantee that third-party services will be received. If the facility's efforts to make arrangements for third-party services are unsuccessful or declined by the resident, the facility must include documentation in the resident's record explaining why its efforts were unsuccessful. This documentation will serve to demonstrate its compliance with this subsection. Conditions allowing residents to work in the facility.
Residents may not be required to perform any work in the facility without compensation. Residents may be required to clean their own sleeping areas or apartments if the facility rules or the facility contract includes such a requirement. If a resident is employed by the facility, the resident must be compensated in compliance with state and federal wage laws. Independent living residents, as referenced in subsection 59A-36.015 in parentheses 3, Florida Administration Code, who occupy beds included within the licensed capacity of an assisted living facility, but do not receive personal, limited nursing, or extended congregate care services are not counted as residents for purposes of computing minimum staff hours. At least one staff member who has access to facility and residence records in case of an emergency must be in the facility at all times when residents are in the facility. Residents serving as paid or volunteer staff may not be left solely in charge of other residents while the facility administrator, manager, or other staff are absent from the facility. Demonstrate knowledge of the mandatory abuse, neglect, and exploitation reporting requirements for ALF staff. Abuse. The telephone number for lodging complaints against a facility or facility staff must be posted in full view in a common area accessible to all residents. The telephone numbers are the long-term care ombudsman's program 1-888-831-0404, Disability Rights Florida 1-800-342-0823, or the agency consumer hotline 1-888-419-3456, and the statewide toll-free telephone number of the Florida Abuse Hotline 1-800-96-ABUSE or 1-800-962-2873. The telephone numbers must be posted in a close proximity to a telephone accessible by residents, and the text must be a minimum of 14-point font.
The facility's abuse prevention policies and procedures. Abuse, neglect, or exploitation must be reported to the Department of Children and Families. Recognizing and reporting residents' abuse, neglect, and exploitation. The facility must use its abuse prevention policies and procedures when offering this training. Live in a safe and decent living environment, free from abuse and neglect. Residents for whom a physician has prescribed a physical restraint must have a written care plan for the use of the physical restraint. The care plan must be developed within 14 days of the device being prescribed and prior to the use of the resident. The care plan must specify the device prescribed for use. The maximum amount of time the resident is to have the restraint applied each day, and what manner and frequency staff will monitor, observe, and report to the physician any injuries, increase in agitation, signs and symptoms of depression, or decline in mobility or function related to the use of the prescribed restraint.
Facility staff must ensure that the device is applied appropriately and safely. The resident's physician must review the appropriateness of the continued use of physical restraint annually, and documentation of this review must be maintained in the resident's record. If the resident's ability to independently remove or avoid the device fluctuates, the device must be considered a physical restraint and all requirements of this subsection apply. Demonstrate knowledge and understanding of surrogate decision makers for residents, including guardianship, in order to protect health, safety, and welfare, including financial resources of residents. Example: do not resuscitate orders. Training. Newly hired facility administrators, managers, direct care staff, and staff involved in resident admissions must receive at least 1 hour of training in the facility's policy and procedures regarding DNROs with 30 days after employment. Currently employed facility administrators, managers, direct care staff, and staff involved in a resident's admissions must receive at least 1 hour of training in the facility's policies and procedures regarding do not resuscitate orders, or DNROs. Policies and procedures. Each assisted living facility must have written policies and procedures that explain its implementation of state laws and rules related to do not resuscitate orders, DNROs. An assisted living facility may not require execution of a DNRO as a condition of admission or treatment. The assisted living facility must provide the following to each resident or resident's representative at the time of admission.
Form SHHS-4-2006, Healthcare Advance Directives, The Patient's Right to Decide, April 2006, or with a copy of some other substantially similar document which incorporates information regarding advance directives included in Chapter 765 Florida Statute Form SCHS-4-2006 and available from the Agency for Health Care Administration. Contact information provided below and website. DH Form 1896. Florida Do Not Resuscitate Order Form, December 2004, which is hereby incorporated by reference. This form may be obtained by calling the Department of Health's toll-free number, 1-800-226-1911, extension 2780, or online at the link below. There must be documentation in the resident's record indicating whether a DH Form 1896 has been executed. If a DH Form 1896 has been executed, a yellow copy of that document must be made a part of the resident's record. If the assisted living facility does not receive a copy of a resident's executed DH Form 1896, the assisted living facility must document in the resident's record that it has requested a copy. The executed DH Form 1896 must be readily available to medical staff in the event of an emergency. An assisted living facility's license is subject to revocation pursuant to Section 408815 Florida Statute if, as a condition or treatment or admission, the facility requires an individual to execute or waive DH Form 1896. DNRO procedures. Pursuant to Section 429.255 Florida Statute, An assisted living facility must honor a properly executed DH Form 1896 as follows. In the event a resident experiences cardiac or pulmonary arrest, staff trained in cardiopulmonary resuscitation or a health care provider present in the facility may withhold cardiopulmonary resuscitation, artificial ventilation, cardiac compression, endotracheal intubation, and defibrillation. In the event a resident is receiving hospice services and experiences cardiac or pulmonary arrest, facility staff must immediately contact hospice staff. The hospice procedures take precedence over those of the assisted living facility.